Thank you, Mr. Chairman, for leading on this issue for so steadfastly and for so long, and for holding this important hearing on foreclosure mediation programs in bankruptcy courts to better protect consumers. You just have been a real leader on bankruptcy issues, and I applaud you for your work in this area. I want everyone to forgive me. I'm bouncing between here and an Energy Committee hearing, so I'll be back and forth. Many problems have come to light since the beginning of the foreclosure crisis. Most recently, we've seen mortgage servicers fraudulently signing affidavits to execute foreclosures when they have zero personal knowledge of the individual borrower's situation. This problem, known as robo-signing, is particularly troubling to me. Last year, I wrote letters to Ally Financial and J.P. Morgan Chase calling for a suspension of all foreclosure proceedings until this issue has been resolved. I got a form letter from Ally touting their efforts to complete HAMP and non-HAMP loan modifications, and it's nice to see that they don't treat their homeowners who they're servicing any worse than they treat a senator. I also joined with Senator Menendez in asking GAO to investigate the role of federal regulators in overseeing foreclosure proceedings. While some mortgage servicers have taken action on this issue, I worry that it is a day late and a dollar short. Borrowers are at such an extreme disadvantage in these foreclosure proceedings that I fear robo-signing is only one of many ways that servicers have been able to take advantage of vulnerable families and homeowners. And because most homeowners don't have access to legal advice or even basic counseling, most of these abuses never come to light. Some of you may have heard me tell the story of Takora, a Minneapolis homeowner who fell behind on her mortgage when her payments went up. She entered the Homeowner Affordable Mediation Program, or HAMP, but was told by her mortgage servicer that her file was closed because she had, quote, declined a final modification of her mortgage. The problem was she actually hadn't done that. Takora is working with Twin Cities Habitat for Humanity, a wonderful nonprofit that is helping her fight this mistake and stay in her home. Every homeowner deserves this type of assistance. Unfortunately, not everybody gets it. Minnesota has taken important first steps to address this matter by requiring mortgage service providers to provide homeowners with pre-foreclosure notices that include foreclosure prevention counseling resources. Every state needs to adopt this and other services to help give homeowners a fighting chance. I'm pleased that Judge Drain could join us today to tell us about the innovative foreclosure mediation program that was developed in the Southern District of New York. In Minnesota, more than 22,000 people filed for bankruptcy this year. This is a record number and is more than 87% higher than the bankruptcy rate in 2007 before the recession occurred. Although I realize bankruptcy reforms won't help all families go through devastating foreclosures, these types of mediation programs are one important way that we can help families in Minnesota and elsewhere to stay in their homes. Thank you, Mr. Chairman. I look forward to hearing the witnesses' testimony. Well, I want to continue with this because Mr. Grossman, I'm a little confused because in your previous answer, you said it would require coercion for this to be done, that for this kind of settlement would require coercion, is what you said. And so now it seems like your answer is very different when confronted with the reality, when taken out of your theoretical framework in answering the ranking member. You said it would require coercion, but now what I see from Judge Drain's court, as you just acknowledged, is that there is no coercion there. So to me, let's get to the reality of this and what's really happened as opposed to some theory. We've heard that Judge Drain, that the concerns raised by the other witnesses that lenders are coerced to negotiate better terms for the loan. Can you tell me what percentage of loan modifications in your program involve a reduction in principal to the loan?
Not that many. Most of them involve significant reductions in interest rate, 12% down to 3, 4, 2%. Waiver of fees, waiver of default interest, and rolling defaulted principal payments into the back end of the loan. Where there has been a principal reduction, it's usually on a second mortgage, where the second mortgage holder realizes that in a foreclosure they'd get nothing, so they're getting a better deal by having a principal reduction. Or where the mortgage holder has significant document problems and might not ever succeed in foreclosing. In that case, I have approved very significant settlements where the principal was reduced a lot, but that was really a different, that was a legal issue as opposed to an economic issue.
We're talking about, and all this is, to me, part of a whole, pieces of a whole. During Mr. Grossman's testimony, he talked about all the stuff that, all the opportunities that people have on the way there, and why do we need this in addition? But in your testimony and in response to the questions, you said this is very often the first time that these homeowners have gotten this information. And Mr. Rayo, Senator Grassley very rightly said we need to fix HAMP as part of this. Now, I proposed legislation that actually passed the Senate last year with, in fact, Senator Grassley voted with it, along with quite a few Republicans, to create an office within HAMP to provide assistance to homeowners navigating the system, so the Homeowner Advocate Office. And unfortunately, it didn't get passed by the House. But given your experience, I mean, my experience, people in Minnesota, is the servicers don't provide them with information. And the servicers either are incompetent or lie to them, or, you know, and the idea of a homeowner advocate office is that there's some place in the Treasury, and we paid for this with Treasury funds, it didn't cost a thing, that they have a homeowner advocate in the Treasury office. And so given your experiences working with homeowners in foreclosure proceedings, you see the value of having a homeowner advocate involved in the proceedings.
Well, Senator, I think something obviously is required. A homeowner advocate could potentially fill that role of providing the impetus for servicers to be accountable for their actions. And most importantly, as we keep saying over and over and again today, for them to simply make decisions which they are required to do under the HAMP guidelines. Mr. Grossman referred to these loss mitigation programs as imposing a burden on services to have a decision maker. That is their requirement. Under as a participating servicer, they are required to make decisions and to do it within 30 days. So yes, I believe a homeowner's advocate office could help enforce, for example, that requirement. I think the other legislation passed by Congress as part of that the Dodd-Frank bill in requiring disclosure of information such as the results of the net present value test will also be helpful for achieving accountability with the HAMP program, so that the parties, especially the homeowners and their advocates, can know whether there's been a proper denial of their application.
Thank you, Mr. Chairman. I really have enjoyed listening to the chairman, who really has bored into this subject and has been on this for so long, and enjoyed listening to the former Attorney General of Connecticut for, what was it, about 50 years? Something like that. And so, I mean, these guys, I would actually like an answer to the chairman's question from Mr. Grossman, which of the three requirements do you object to that someone with full authority for the lender in the loss mitigation program be there, that they show up during the loss mitigation program, and that they act in good faith? Which of those three do you object to?
Senator, as I stated, my objection is with the mandatory nature of the program. I suppose you could take that as being all three, although I don't think that would be strictly an accurate way of describing it, but it's the mandatory nature of the program.
Okay. The mandatory nature in a bankruptcy court, where as a bankruptcy judge, Judge Drain, you have the authority, your job is to resolve all these claims on someone when they go bankrupt, right?
Yes.
And you have authority to do these things, right?
Yes. Well, I'll give you the example. I have forced one lender to continue loss mitigation, one. That was a lender that had a $200,000 equity cushion, so they wouldn't have gotten relief from the automatic stay. And they simply were not paying any attention to the borrower. I said, I'm not going to terminate loss mitigation until you look at this borrower's financial information. I think I have the authority to do that because they weren't going to get relief from the stay anyway for months because they had an equity cushion, $200,000. But that was an exception. I mean, most of the time, and by most of the time, I'm saying like 99% of the time, they want the structure because that's why you do mediation. You want someone there to keep the parties focused and to not let them throw hogwash up at you and get the deal done.
Thank you. Mr. Rayo, one last question. I've been very concerned with the issue of robo-signing, in which employees of mortgage servicers have improperly signed affidavits executing foreclosures without having actual firsthand knowledge of the facts of the mortgage. Would loss mitigation programs in bankruptcy courts have prevented this problem, or at least mitigated the problem, or could it prevent a similar issue in the future by ensuring that more attention is paid to each individual case?
I think they definitely could mitigate the problem, primarily because bankruptcy courts have been addressing this issue for some time. In my written testimony, I listed a number of cases dating back 10, 15 years in which bankruptcy courts have encountered problems with false affidavits and false documents being filed and have sanctioned parties for filing them. So although it's become sort of popular in the press right now and there's been a lot of coverage of it, it's actually not at all new to bankruptcy courts, and bankruptcy judges have done a very good job of ensuring the truth and veracity of the documents that get filed in the court. So having it be part of a loss mitigation program would only improve that.
Thank you, and thank you all of you for your testimony. Thank you, Mr. Chairman.